Hello aspirants, welcome to Get.Set.Law Law Wednesday series. In this series, today we are going to discuss the Gyanvapi Mosque dispute. I am sure that all of you must have heard about it because in the previous time also we have seen the parallel incidents like the Ram Mandir issue, the Ram Mandir which is Ram Janambhoomi versus Babri Masjid dispute. Similarly, in this case also, there is a issue of a mosque and a temple which is standing parallelly, and that is why the claim by both the communities that this premise belongs to whom in reality. So today we will dive down in this issue and we will see from the beginning that how it all started. As we have seen recently that there are multiple cases which have been brought up against this specific place. So let's see what has happened. The Gyanvapi Mosque stands adjacent to the Kashi Vishwanath temple in Varanasi. As there are three prominent issues in the country with respect to temple and mosque. As I just mentioned about the Ram Janambhoomi and Babri Masjid, there is another case which is lying in Mathura, Krishna Janambhoomi and Shahi Idgah temple. Again, Mathura Krishna Janambhoomi and Shahi Idgah temple is standing parallelly to each other, and the claim is very same that the temple has been broken and the mosque has been built on the premises. So we can see that the same issue has taken over here, where there is a claim that the Gyanvapi Mosque has been made upon the actual and original temple premise of the Kashi Vishwanath temple. And this we can see what is available in our historic data, which says that in the 17th century Aurangzeb ordered to break the temple and build the mosque over there. So whole premise is built upon this, that the Gyanvapi Mosque is built upon the original Kashi Vishwanath temple. So many claim that the Kashi Vishwanath temple, the premise what we have right now is not the actual and original one, but it has been made post the destruction of original place. So we will see that how litigation started in this case and where are we right now and what will happen next. So the first petition came in 1991. Now this is a very important year to remember. 1991, with respect to this, there had been a prominent record. So first is we got our landmark liberalization, privatization, globalization policy, with which we got ourselves saved from the financial emergency. Second, which is very much connected to this incident, is the destruction of the Babri Masjid by the Kar Sevaks of the Bharatiya Janata Party. So this has been claimed that in 1991, 32 people led, the whole community led by the 32 people from this Kar Sevak community, they went and they destroyed the Babri Masjid, and thereafter the issues came up and even the petition has been filed in the Kashi case also, because from 1991 it had been started that people came to notice that there is a claim that we have to take about our own worship places. So same 1991, the first petition has been filed in the Kashi, and the petitioner claimed the three demands. The first demand is declare the entire Gyanvapi complex as a part of Kashi temple. Second, removals of Muslims from the complex area, and third is the demolition of the mosque. So these were the three demands put up by the petitioner. In the second petition was filed in 1998, which is after 7 years, and this was filed by the Anjuman Intizamiya Masjid Committee. Remember this name, this committee will come again in our later slides. So this case was filed in the Allahabad High Court, and they raised the issue that dispute between the temple and the mosque cannot be dealt by the civil court as it is not permissible by law. Which law? I will tell you later. What was the result of this petition? So the result was that the High Court stayed the proceedings for whole of this 22 years. So the 1998 they filed the second petition in challenge to the first petition which was filed in 1991, and now in 1998 the proceeding was stayed for 22 years. So we directly come to 2019. 2019 this case was revived when the follow-up petition has been filed with respect to 1991 petition, which was the very first petition in this case, and again there had been a demand that there has to be an archaeological survey. This petition is again a similar one because archaeological survey started in 2017-2018 for the Ram Mandir issue also, under the guidance of the committee made by the Supreme Court. So following that, people addressed this in the petition that there has to be archaeological survey of the Archaeological Survey of India must submit the report claiming whom this property belongs to. 2020, again as I mentioned, Anjuman Intizamiya Masjid Committee, we will use AIM committee. So they again opposed the petition. They said that ASI survey cannot be done for the entire Gyanvapi area. Then again a petition has been filed saying that 1991 petition shall be reheard in the court. Thereafter 2021 the court again a case has been filed where the Places of Worship Act 1991 was taken up by the bench, in which there was headed by the former Chief Justice of India S.A. Bobde. So they wanted to examine the substantiality and the constitutionality of the Places of Worship Act and whether the lower court can take up this matter or not. Now this was the law which had been claimed by the AIM committee in 1998 that they cannot take up this matter as it is not permissible by the law. So the law here is Places of Worship Act 1991. Now what role the Places of Worship Act 1991 plays? The Places of Worship Act 1991 says that there cannot be any dispute with respect to the religious places, with respect to the status of religious places as declared in 1947, and the only exception granted was Ram Mandir and Babri Masjid issue. So that is why the AIM committee filed this case that it is not permissible by law. Then in 2021, the bench demanded that the central government should respond on this PIL which has been filed by the advocate Ashwini Kumar Upadhyay. So they challenged the validity of the court, and then the matter started and the court was deciding what should be the grey area for this Places of Worship Act 91. Then in next year, April 2022, on the basis of the PIL which has been filed in 2021 seeking the constitutionality of Places of Worship Act 1991, the lower court of Varanasi, they appointed an advocate commissioner and they ordered for videography survey of the complex. So the entire Gyanvapi complex has now come under the ASI purview, which will be done by the videography survey. Then again AIM committee came in front and they said that this cannot be done. They filed a counter petition. They said that in the Allahabad High Court, when the AIM committee put up the matter, they said that we have already put up this before, that the ASI survey cannot be done in the entire Gyanvapi area as this is barred by the Places of Worship Act. But this time Allahabad High Court denied their PIL and they upheld the order of the Varanasi District Court which allowed the videography survey. But hereafter, AIM committee went to the Supreme Court. They filed a special leave petition under the Article 136 of the Constitution and they said that the order of the Allahabad High Court is ultra virus because they cannot order the ASI survey as this is barred by a specific law. In 2022, the videographic survey of the Gyanvapi complex began as we saw that the SLP filed by the AIM committee in 2021 was discarded by the Supreme Court, and Supreme Court upheld the order of the Allahabad High Court and they allowed the videography survey to be done by the ASI. So finally it took an year, but it started in May 2022. So the videographic survey began in the Gyanvapi complex And to overlook this issue, the court appointed the senior advocate Vishal Singh to supervise the whole matter. And he has also been appointed as a special advocate commissioner. So under his guidance, he took the responsibility to conduct the videography survey in a very reasonable, in a healthy manner, so that there cannot be any clash or any dispute between both the communities. Later on, in October 2022, Varanasi District Court rejected the plea for the carbon dating of Shivling. Now, the Hindu community went forward and they filed this petition in the Varanasi court that there has to be a procedure of carbon dating so that they can declare the date of the Shivling. So it has been claimed by the community that Shivling is lying in the Gyanvapi Mosque at a certain area, and that is why carbon dating is important, so that we can determine the date or year of the Shivling. In November 2022, when the matter escalated, the Supreme Court said that they will set up a dedicated constitutional bench to hear this particular case. And finally, in May 2023, Allahabad High Court ordered the determination of the age of Shivling using the modern technology. So the committee had been set up before, as we saw under the advocate Vishal Singh, who was acting as the advocate commissioner, and in the videographic survey nothing substantial has been found to prove the claim of the either parties. That is why Supreme Court has reiterated that the Allahabad High Court should take up this matter and decide what should be done. So, following that, in May 23, Allahabad High Court ordered that the age determination has to be done for the Shivling so that the matter can be solved. Then again, Supreme Court deferred that scientific survey to determine the age of Shivling may not be correct, or it might create further dispute between both the communities, and they delayed the process. So Supreme Court stayed the order of the Allahabad High Court to start the survey to determine the age of the Shivling. Then again, back in July 2023, Varanasi District Court directed the Archaeological Survey of India that they can start the survey including excavations wherever necessary, and they should determine the mosque was built at a place where the temple existed earlier or not. Because if we go back to the 1991, the very first petition, this was the demand which was raised that the original temple had been removed by the Mughal rulers and then they built the Gyanvapi Mosque. So this is very important that Varanasi court wanted to set up that we want to decide whether this property belongs to the Gyanvapi or the Kashi. Again, the matter went to the Supreme Court and Supreme Court halted the ASI survey at the premises. So this was the history so far, and now we will see that what is going on recently and what can happen next. So in the August 2023, in the last month, in the month of August, so the Allahabad High Court allowed that the scientific survey should take place in the Gyanvapi premise in the interest of justice, because we know that this matter is sensitive and both the communities are involved and they wanted to claim their own regards. So, in the interest of justice, the Allahabad High Court has ordered that there has to be survey so that the matter can be decided and both the communities should not fight in this. Then again, AIM committee has now moved to the Supreme Court and they challenged the decision of the Allahabad High Court, as this committee had been challenging before also to stop the ASI survey. But this time, Supreme Court allowed the ASI survey but put the rule that there should not be any kind of excavation, which the Varanasi court said that whenever it is necessary, the excavation can be done. So this is the final update which Supreme Court gave, that there has to be no excavation and there will be no survey of the Wuzu Khana area. So there is a Wuzu Khana area where there have been claims that Shivling is lying. The Supreme Court said that Wuzu Khana area cannot be touched, there will be no survey in that area and there shall be no excavation, and ASI should do the survey. Also, Supreme Court ordered that there cannot be any media coverage of the ongoing survey, and this has been put into the function by the Varanasi High Court, Varanasi District Court, that they released the order that there should be no media coverage. Why? Because we know that when the media covers the matter, there are different kinds of perceptions which have been given by media. So seeing that perception, hearing that perception which may not be reality, so this will further exaggerate the matter and it might create dispute between the two parties. So this was the issue of Gyanvapi Mosque and the Kashi Vishwanath temple. So let's wait for the ASI survey report. Yet the report has not come. So detailed report of the ASI survey will be given to the Supreme Court, and on the basis of the report of the ASI survey, the Supreme Court will decide the matter. So this was all for today. Stay tuned. See you in the next video. Thank you.